Hello, hello. We are live to no one, so we just getting started. So welcome. This is the inaugural live stream. So we are no longer live stream versions. This is our time to shine. So this morning it's already been a bit crazy in the courtroom. Darrell Brooks indicated that he had filed a motion, uh, a Brady motion, that some discovery had not been properly brought to his attention by the one of the prosecutor's witnesses, and the judge immediately threw it out. It had to do with the red SUV and a recall that had taken place with that red SUV.
Madam Clerk, might I please get verification that the audio and video are working in the neighboring courtroom? All right, thank you. I do have verification. There are headphones on the table in front of Mr. Brooks should he choose to wear them. I see he's reading from a book at the moment. I do need to make a record that this morning, although Mr. Brooks was not raising his voice, there were repeated interruptions. He wanted to debate rulings that I made after the fact. Just this morning alone, about 26, 27 different times he interrupted me or spoke over me. Once I made a decision on his motion to dismiss and his request to recall a witness, he then asked if for written findings. I denied that. He then asked for what law I was following. I indicated I wouldn't explain that further, that I already made an oral ruling. He asked for a stay. He asked for dismissal. All of those things I either denied or said I wouldn't answer, specifically as it relates to the request for an interlocutory appeal, since I would not be the judge or court to which a request would be made. That is something that would be made to the Court of Appeals. Although I would have authority to grant a stay pending appeal, there is no appeal that's pending. I gave Mr. Brooks multiple opportunities.
Well, the judge has definitely changed their tune today compared to late last week.
Interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and would be taken to the neighboring courtroom. I believe I gave that
but
at least twice. Of course, this comes on
if anybody's
the
watching
record before this court over the first 15 days of trial, where Mr. Brooks has, by his conduct,
well, the judge obviously has had
right
enough.
to be present
over the
on a number of occasions
made
due
the
to his
decision
conduct. I do appreciate that this morning he didn't yell at me, he didn't raise his voice, he didn't speak in an angry tone. But given the history in this case leading up to today, and knowing what this court needs to get through in terms of whether he has any witnesses or whether he intends to testify himself, there's a very important colloquy I need to have and an advisement of his rights that I need to go through. And I simply am not able to do that with him constantly interrupting me and then not respecting the oral rulings that are made. Of course, at any point in time, Mr. Brooks can ask to be brought back over to this courtroom under Illinois versus Allen. Of course, he needs to pledge that he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I, of course, have repeatedly, even without him making such a pledge, brought him back into the courtroom where I felt a sufficient time has passed. And he, at many times, has been able to conform his conduct. I would note during the vast majority of the testimony that was provided during the state's case, he was in the courtroom. If not during the entire time, he was able to cross-examine witnesses. We had a couple of issues during the testimony of witnesses he called. And of course, last Friday was, in my opinion, probably one of the most challenging days, I should say, to date.
Doesn't look like
my
he's
hope
reading.
That we can continue with Mr. Brooks in this courtroom. At some point today, I'll certainly invite him back over when I get through these advisements. Mr. Brooks, you have been muted. I will make that, put that on the record as well. I will unmute though and ask Mr. Brooks, because you did not answer the question previously. Other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse to call today? I need an answer to that question, sir.
So we address the subject matter jurisdiction that we haven't addressed when I was just over here, or since I've been over here? Are we addressing subject matter jurisdiction?
I'm going to mute him just for a second. No, I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction. I have issued a written decision on that. He has not filed any type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point his request to dismiss the case based on a lack of subject matter jurisdiction. Mr. Brooks, I will be asking you a couple of questions. I do need a response. I am unmuting you. Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
This is the jurisdictional challenge right here. So are you going to address subject matter jurisdiction and prove it for the record or not?
So I've asked Mr. Brooks twice now whether he has any witnesses to call other than himself. He has declined to answer that question. Sir, if you fail to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity, you will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response at all.
Am I unmuted?
You've been unmuted, sir.
You just said I was muted. I'm not sure. I don't know when you did it or not.
Well, me muting you doesn't affect you being able to hear the court, because that only mutes your audio coming into this courtroom. I confirmed already that
my audio muted to begin with.
That is simply a misstatement. I confirmed with the bailiffs that the audio and visual were working.
Why is my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here. So I trust that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning, and specifically now? I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning? He's been unmuted for a while now. We can obviously hear him. I will ask Mr. Brooks a third time for the record. He's finally putting on headphones. Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear. I don't need to be muted.
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false.
I can say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record, sir.
You are lying on the record.
All right, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses other than perhaps himself. I then specifically asked him about Dawn Woods because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself. I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. I would direct Mr. Brooks to the case of State versus Anthony, although that squarely dealt with a person's right to call to be themselves a witness in their own case. They talk at length in that case about how rights, even constitutional rights, can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon conduct. Although the criminal defendant does have a right to present the defense, doing so must be guided by the rules of evidence, the rules of procedure, and also with respect for the dignity, order, and decorum that is needed in the courtroom. Mr. Brooks has demonstrated this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and a disruption tactic. When considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has forfeited his right to present further witnesses. I would like to go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that. I ask Mr. Brooks to put on his headphones if he is unable to hear me, and just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point. He's unmuted. I've also been advised by not just the bailiffs who are over there, who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear. Mr. Brooks, I would like to go through with you your right to testify and your right not to testify. We are at the stage in the proceedings where it is important that this court conduct a colloquy with you I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin, 20. Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him, although I haven't seen a page turn. If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial
He
testimony.
thinks it's not going to move on.
Did you hear me advise you of that?
She's decided to move on.
No response by Mr. Brooks. Sir, you also have a constitutional right not to testify.
She means business today, folks.
If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that? Once again, no response by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that? There's no response by Mr. Brooks. It's my understanding that Mr. Brooks has the equivalent of a 12th grade education, that he attended school either up to or through 12th grade, and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education. He is currently in custody, of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours or any drugs or any alcohol? I'm not receiving a response to that. I'm aware that he's able to read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel, and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understand, he can read, write, and understand the English language.
Am I unmuted?
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you're going to verify it on record?
So he did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24 hours.
This guy.
I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial? Although he turned and said, what did you say? Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
So if you can hear me, I don't hear everything you're saying, and you know I don't hear everything you're saying. So cut the crap.
Mr. Brooks has interrupted with very disrespectful words at this moment. I believe that he is feigning his inability to hear and that he's done so throughout this case. There's absolutely no indication. He puts the headphones on when he wants. He takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that, and I mute his audio, that it mutes his audio, are simply false.
Yeah.
So
Mr. Brooks, have you made...
Am I still unmuted?
You are, sir.
He keeps doing
And
that.
I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder than it is in this
He's
one.
just causing trouble now.
Stop making false records saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here. That's what I said. So I would appreciate
So he's going to want to come back in.
Clear and correct.
He's going to say, I want to come back in.
Say that for him to make that distinguishing statement.
I'm sitting right here. Don't you see me looking all up to the microphone so you can hear me?
I don't have an issue hearing you at all, sir.
Can you hear me when I'm right here?
Yeah.
I can. Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
No. Have you made a decision to testify?
I will ask you again, sir. Have you made a decision to testify in this case?
Subject matter jurisdiction? Have you made a decision to be impartial?
That's his cop out. Does that every time.
The answer, if you have a claim against me,
I'm going to mute him for the moment just because, once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with him regarding his right to testify. He is asking me about subject matter jurisdiction. He's making statements about this court that are disparaging and about my oath. Again, a clear attempt, in my opinion, to simply stall these proceedings and to disrupt them. I will unmute him and I will ask him for a third time with the understanding that if he fails to answer the question in the affirmative, I will interpret his failure to respond as a no, and that he is not going to testify. So once again, I am unmuting him. Sir, have you made a decision on whether to testify in this case? There's no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case?
Am I unmuted?
Yes, you have been. Sir, do you want to...
How long have I been unmuted?
Sir, do you want to testify in this case?
This is getting annoying.
You just said you was muted. So when have I become unmuted? Or did you even mute me in the first place?
Mr. Brooks, I'm asking you one last time. Do you want to?
Because I haven't heard nothing that you asked. So how you gonna ask me something and then just answer for me?
Mr. Brooks, do you want to testify? All right, I'm going to answer. Yeah. I'm going to mute him again. Again, it is very clear to this court that he uses the statement that that he can't hear as a means to delay. It's a distraction. It's very evident
he's
that
so frustrated.
And that
they don't want to listen to me.
To willfully not answer this court. This court, as I indicated earlier, is tasked with the
I just want him to come back in the room. He's
duty
much more comical.
To ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions. I personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make the appropriate findings. Without him providing answers, this court is left with no choice but to find that he is forfeiting his right to testify on his own behalf. This court must also preserve dignity, order, and decorum. Again, ensure relevant and admissible evidence is presented, and also honor the defendant's right to present a defense. The simple requirement that he answer questions is required, frankly, due to the defendant's prior conduct throughout this trial. His repeated defiance, his repeated
he made a big deal last week.
His repeated failure to follow
indicated
simple
that
rules
his
of
mother was
courtesy
going
and
to
decorum,
he was going to call his mom to the stand, and the state refused to assist in that process. So they've been assisting him with all of the witnesses that he wanted. They helped with subpoenas, helped with scheduling, and to get them to the courthouse to testify. But for the mother, they wanted him to take care of that process himself. And he said there would be no problem that his mom would do anything that he wanted her to do, and that if he said to come, she would be there.
The court, the prosecutor,
so it looks like maybe she decided
the
not
jurors, the public. Absent an adherence to these simple rules, including the rules of evidence, the rules of procedure, and the rules of civility and decorum, and without a pledge by Mr. Brooks that he will follow these things, then on balance, this court will find that he has forfeited his right to testify. I've now made a much more full record of what is at stake, and I will give Mr. Brooks an opportunity again.
Here we go. Another opportunity.
Go through the colloquy with the court regarding his right to testify. I am unmuting him.
She came in really strong.
Once again,
we're over.
But
she's
fails to answer these questions,
opportunity after opportunity
right to testify
this may be it,
by his own conduct. I would acknowledge that such a procedure is certainly not ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced the court to make this determination. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Mr. Brooks, are you aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
Mr. Brooks, do you understand and are aware that you have a constitutional right not to testify?
I don't understand. No, I don't understand.
Are you aware that you have a constitutional right not to testify?
I don't understand, and I'm not aware, so why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify, and that if you choose to testify, that you would be subject to cross-examination by the state. Did you hear me say that?
He thinks this is going to work. He thinks it.
He is willfully choosing not to answer that. Sir, you are also advised that you have a constitutional right not to testify.
Your Honor, with all respect, you've been trying.
Did you hear me say that?
I didn't hear you ask me anything.
Come on.
Sir, stop talking and I'll ask it again.
He hears the question.
Sir.
She asks, do you understand? And he says,
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do this one last time. All right, then let's. Once again, Mr. Brooks is being disrespectful. He is blurting out information. He reverts back to subject matter jurisdiction. He accuses this court of not honoring its oath. He just accused me of practicing law without a license. Again, all attempts to deflect away. I'm going to mute him once again. This court has simply tried to no avail to get Mr. Brooks to answer simple questions, confirming on the record that he has been advised that he has a constitutional right to testify, and that he also has a constitutional right to testify. I was very clear prior to unmuting him and telling him that I would go through these questions once again, that I needed him to follow the rules of decorum and civility and not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions.
Unfortunately, this trial hasn't been as exciting as some of the other trials that I've watched
to
recently.
delay these proceedings, to disrupt these
it's got its moments.
He reverts back again to things like subject matter jurisdiction.
Yeah, the subject matter jurisdiction thing has been since day one of the trial. He brings that up continuously. That and the fact that he doesn't recognize his name. Darrell Brooks, he says he doesn't recognize that, and then he wants to call the state of Wisconsin to the stand, and he continues to make a big deal that his accuser is, because it's Wisconsin versus Darrell Brooks, that his accuser isn't there
and
to
based
testify.
upon pursuant to State versus Anthony, and looking at the balancing test,
he started off with the sovereign citizen thing at the very beginning. He kind of lost that train of thought. He weaves back and forth with all of his arguments because they contradict. Any argument that he makes, he contradicts himself by the end of the day.
Allow Mr. Brooks to get on the witness stand unfettered without an acknowledgement that he will honor the rules of procedure, that he will abide by the rules of evidence, that he will honor rulings that are made by the court.
I don't know that the court would want to testify.
This trial, that when this court makes a ruling that he disagrees with, he tries to engage
because I think he would end up
argument.
She would have to remove him from the stand,
provided the legal basis,
and it would only cause more issues.
Or,
then the appearance that he's not letting him testify. So I think it's. I mean, I'm not a lawyer, but I think it is better that he doesn't get on the stand and potentially run into problems.
Anthony, this is a case where the Wisconsin Supreme Court was faced with a similar situation, although not as egregious as I would say here, because in State versus Anthony, that was not a case where the defendant was never removed from the courtroom based upon his conduct. Although in State versus Anthony, they noted it isn't a requirement to forfeit your right to testify to previous to that be removed from the courtroom. So not as egregious as a case, but this court has a history over 15 days of trial where Mr. Brooks has repeatedly been removed from the courtroom, where he has repeatedly demonstrated he has absolutely no regard for courtesy and decorum. He is what I would describe as a stubbornly defiant individual who simply wants to say what he wants, when he wants, without a filter, without regard to the rules of evidence and the rules of procedure.
Celebration.
As State v. Anthony discussed, the right to testify, although a fundamental constitutional right grounded in personal autonomy, is not.
So this case is going to wrap up
absolute. For example,
really quickly
there's no
now.
Constitutional right to commit perjury. There's
might
no
even
constitutional right to present irrelevant
closing arguments
evidence.
When it goes to the jury tomorrow.
Moreover, a criminal defendant's right
maybe
to
by the
present
end of the day,
relevant
maybe we
testimony is subject to
closing
reasonable
arguments.
restrictions. Those restrictions,
Well,
again,
jury
fall
instructions and then closing
primarily under the
arguments.
rules
So
of evidence and the rules of
we'll
procedure.
see. It'd be something
The
if
court
they
in Anthony
did jury
cited
instructions
the court,
this morning,
the U.S.
closing
Supreme
arguments,
Court
give the
from
case to the
Arkansas
jury
versus
and
Rock, where in
see how quickly they could come back.
that
We
court
might have
stated the right to
a
present
verdict by the end of the
relevant
day.
testimony is not limitless and may in appropriate cases bow to accommodate other legitimate interests in the criminal trial process. For example, numerous procedural and evidentiary rules control the presentation of evidence and do not offend the defendant's right to testify. Throughout this trial, Mr. Brooks has repeatedly accused this court of violating his First Amendment rights of free speech. I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited in the court of law for the very reasons cited by the Supreme Court in Rock. The takeaway from Arkansas versus Rock is that a defendant may forfeit his right to testify by his conduct, whether a criminal defendant may forfeit his or her right to testify through conduct incompatible with the assertion of a right was reviewed by that court. That court went on to discuss waiver and forfeiture and ultimately went on to conclude the following. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. The balancing test that this court must go through are the interests, again, as I've already stated, for the rules of evidence, the rules of procedure, civility and decorum, and balancing all of that against Mr. Brooks's right to testify. This court is not making an arbitrary decision. The decision I make here today is, in my opinion, proportionate to the conduct demonstrated by Mr. Brooks throughout this trial, and specifically today, based upon his failure to even engage the court in a simple colloquy regarding his right to testify and his right not to testify. He was repeatedly warned that the failure to answer the questions would be taken by this court really as no, meaning the specific question, have you made a decision? And is for all of those reasons that this court will make a finding he has forfeited his right to testify. With that, then, there are no other witnesses to present for the defense. Before I bring the jury out, I'll ask the state if you intend to call any rebuttal witnesses.
We have no rebuttal case, Your Honor. Thank you.
All right.
I
would like Mr. Brooks to be brought back over so that he is present in the courtroom when the court advises the jury that the defense is resting. I realize that will be over his objection. I'd ask that he honor that. Mr. Brooks, I'm going to unmute you. If you can pledge to this court that you will honor that ruling and that you won't challenge that directly in the presence of the jury, I will bring you back over for that. Are you willing to make that pledge, sir?
Make what pledge? I'm not making no pledge.
Sir,
You're trying to you asked me a question now I can't answer.
Yeah, no, go ahead, answer.
You're trying to coerce me into violating my right to remain silent. How can you coerce me into my right to remain silent? So you're not going to protect my constitutional rights? Because I didn't answer nothing that you
oh, come on.
That's ridiculous. And you can't make
She's going to state the same case she does every time.
You're violating
she's got the ability to do this.
Sir, if you'd like to testify, then you need to simply go through the colloquy with this court, which I've given you 3 opportunities to do, and you have decided not to.
No, you can't tell me what I decided to do because I didn't decide to do or not do anything.
Are you willing to?
Your Honor, by law, you cannot coerce me.
By law.
I'm not coercing you, sir.
Well, you're making a decision for me based on something that I did not say myself.
Last Friday, I specifically directed your attention to State versus Anthony. I discussed very briefly at the end of the day on Friday the case law that is relevant on this topic, including State versus Anthony, Rock versus Arkansas,
Here we go.
and Chambers versus Mississippi, to specifically put you on notice.
Did you recall what was going on Friday?
Mr. Brooks, I'm going to mute him again. I'm not going to have a debate. I've made a finding. I've given him yet another opportunity. If he's willing to go through the colloquy with the court, he wants to challenge me instead and saying he doesn't consent. His lack of consent to this entire procedure is noted for the record, based on his inability to pledge to this court that he will honor that ruling and be respectful of the jury. I'm going to leave him in the other courtroom. The jury's going to be brought out, and he will remain muted, and I will simply advise them, as I have throughout this case, that he's appearing from another courtroom and that his appearance from the other courtroom should not in any way be held against him or influence their
That's the right thing to do.
Way.
You wasted 40 minutes on his
there are no
rubbish.
Further witnesses for the defense, and then I'll ask the state if there is any rebuttal, and then the jury will be excused for the day, because we will have I anticipate will be a very lengthy discussion on jury instructions.
I don't know how.
Again, I will advise Mr. Brooks that
if she goes back to the passive approach, then it could be pretty lengthy. But he's going to start raising the same issues that he raised during the case.
The rules,
subject matter jurisdiction,
and he will not specifically challenge the court's
etc.,
regarding closing off of his ability to call witnesses. Or
okay, so chances are the jury goes home now. They'll get the case in the morning, and we'll have a verdict probably before lunch tomorrow. Probably before 10 a.m. Eastern. I don't imagine it will take long to deliberate. He's frustrated now. Where's everybody at? Why are they not talking to me? What's going on? So egregious. The behavior of him is just ridiculous. Mm.
Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, at the moment, Mr. Brooks is appearing from another courtroom. This must not be held against him in any way and must not influence your verdict in any manner. At this time, I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal evidence to present.
No rebuttal, Your Honor.
All right, then with that, I will declare the evidentiary phase of this trial concluded. I'm going to excuse the jury for the remainder of the day so that the parties and I go through all of the jury instructions, and I anticipate bringing you in tomorrow morning. Instructions may very well take most of the day. My hope is to then have the closing arguments and then have the case be turned over to the jurors. If not by tomorrow evening, sometime Wednesday morning.
I think jury instructions will take that long.
With that, I'll rise for the jury then. Please turn your notebooks into the civilian bailiffs. I'll get them back to you during deliberation.
I always forget closing arguments, but I mean, if Brooks' closing argument's anything like it's opening, it'll be from the heart. He'll cry, but it'll be 10, 15 minutes. So it won't be any content to it. Who knows what the state wants to do. If I was the state, I would keep it short and sweet. Get it to the jury if they're ready for it.
Thank you. Be seated. Before we begin, I will have Teresa print off what at least we do have for both parties. I'd like to take a short comfort break. I'll invite Mr. Brooks to come back over, and then we'll start with that jury instruction conference. We'll take about 10 minutes. Thank you, everyone. We are in recess.
Okay. All right. Well, that is not much going on there. Pretty benign today. Not really anything exciting. And not, I think we were expecting the mother to testify, and then I thought Brooks would take the stand himself, but I don't think he's ready to. I think the further this thing has gone on, the less fight he's had, and he's ready to give it up. So, cheers to him for finally. Well, he didn't really give up. He complained to the end, but cheers for the judges shutting it down and moving on. So there's not much to talk about other than that. There's quite a bit of news going on around the world and around the states, but we'll cover that outside of this broadcast. I know Legal Vices was covering the trial. I'm sure he's doing quite well with his numbers. I don't know what they are. Let me just take a look. He was going to cover it this morning. And then I think who is it? The Australian guy's going to cover it in the afternoon. So yeah, Legal Vice is doing. Oh, he's got 5K viewers. He's doing great. Wow, he's doing very good. He's really taken off the last month or so, especially with this trial, and he's been on Ricada so much recently. He's been really filling out his niche. Seems like a good guy too. Saw the video of him in Legal Mindset roaming around Korea. So not a lot to talk about now. I mean, it's yeah. Just take a look at that. So just pop in
with blood pressure. Grift on, you old salty sea
Legal
dog.
Vice's channel, doing really well.
Yeah, we've got the blood pressure meds. I took my last one today,
5,000.
so I've got to go and do this tomorrow. Tomorrow is the re-up on my blood pressure meds. Otherwise, I would double up now, so I don't stroke out during all of this.
He is killing.
Definitely not Brandon. Star me. You're starred, brah. Thank you so much. What do you got here?
Get ready to go back to the live stream in a minute. So yeah, it's been an uneventful morning. Not a lot to say outside of that. As Legal Vice has just said, none of it was expected. I think we were all pretty sure that his mom would testify and he would testify or do something. Even if he got up on the stand and filibustered, he would take that opportunity to do that. So it's a little bit of a dead period. The judge is taking a 10-minute recess, and then we'll be back. With the court to start on jury instructions. Now, if my experience, which is limited and it's not legal, it's just watching cases. If my experience with jury instructions is anything like that, it can be pretty monotonous. Now we'll see how Brooks reacts. If he does his typical MO and starts complaining, it could get a bit spicy. But I don't know. After the showing he just had, he may be finished. He may be resolute that his time's up and say, "Screw it, I'm done. I'm out of here," and check out. Start flipping through the Bible again, and then occasionally look up and complain that he's not being heard. That's what I imagine that he's going to do. But hey, we'll see in a couple minutes. So please, if you've not subscribed, please do subscribe to the channel. We are live from Ho Chi Minh City, Vietnam. It is pouring rain outside right now, which is not untypical of this time of year. It's a beautiful, beautiful time of the year. It's cooled down significantly. The weather's great. So, fortunately for this live stream, this is the first live stream of this channel. We've had decent internet quality. For the most part, Ho Chi Minh has good internet. Power, electricity can be a bit fluctuating off and on, but so far so good. We've been very lucky on this particular stream. Everything's worked out just fine. But we will certainly start doing more live streams, especially the late night hours. Do try to do more of these. Try to get them regular. Trying to build some relationships with some of the other streamers as well. I know I'm such a small fish right now. I'm not even really a fish. I'm just fish food right now. But as we progress from being fish food to small fish, I'll start reaching out to a few of the other streamers and try to do some things together, especially those streamers, the American or expat streamers that are based in Asia. Would like to do more with them. The Legal Vices, Legal Mindset in Korea, both those are guys. Legal Vices is starting to take off and growing a lot. Legal Mindset's already a big time streamer, but would certainly like to grow the channel here and be able to do some stuff with them. They seem like super fun guys. I'd like to get them over here to Ho Chi Minh City and be a bit, revel in some of the escapades to do here. But I have messaged Legal Vices and said, as I grow, if just want to start the relationship now, and just let him know I'm not going to grift on him now, but if this is successful and as it gets bigger, if he's willing to try to do something together. So we'll see how that goes with him. He's got a super interesting story. If you've not heard that on Ricada's channel, he's from Utah, has a very religious background and religious life, and did his mission in Korea, and fast forward a few years, went to law school, ended up back in Korea, and the rest is history. But one of those niche lawyers, which you don't hear of a lot of maritime law. And so at least this land-based boy from Tennessee, most of my life in the States at least has been landlocked. Tennessee, Chicago's not landlocked, but it's certainly not a lot of maritime law. And then Phoenix, for the most part, were the three big cities I lived in the U.S. Not a lot of maritime lawyers there. So interesting stories. I'm sure he has a lot of unique tales, especially as much time as he spent in Korea. But like I said, we are in Ho Chi Minh City, or Saigon, the southern part of Vietnam, live streaming. And again, this is our inaugural live stream. So it's not been super busy, but the technology's worked. So I think it's been a success so far. We've not had any major failures, knock on wood. No major failures to speak of so far, except for Darrell Brooks just climbing up and doing his typical thing, and the judge not standing for it today. The judge really went hard on him. Went hard on him at the very beginning, but then at the end gave him much more leeway than I probably would have. But she's ensuring that he has no appeal or real no say going forward. The sentiment's been quite negative toward Brooks of all the comments I've seen. Now you get some of the mainstream papers are certainly kind of not covering for him, but spinning it a little bit. But public sentiment, I think it's pretty straightforward on how the public feels about Mr. Brooks, and he's not done anything at this trial to help himself. I've not seen any remorse. He's cried a couple of times, but most of the time that he's cried, it's been self-pity and talking about how he's had to go through all this stuff, and it's not just victims that, it's his children that are suffering, and he's got a terrible life, and he's not allowed to leave his cell, his jail cell. And it's like one commenter said, well, if you did leave your jail cell, they would kill you. People hate you. And so most of his cries have been, I think, crocodile tears, at least for the victims. Maybe he does feel bad for himself. I'm sure he hates his life now, but it didn't appear that he was living a great life before, but now it's got to be a real hell living behind the bars, as the telemarketing scam guys say, living behind the bars. All right. Well, we are waiting for them to come back. Should be back any minute now. I'm going to tee up the feed so that it's ready to go. Here we go. So we're still waiting. No movement. And it should be any time. Let me get back live in there. So we've got 2 viewers. If love to chat, if you can give me a chat in the box, it'd be great. Or if you've not subscribed, please do subscribe to the channel. We've so this has been the first week of the channel. We started Monday. Oh no, I take that back. We started around Wednesday of last week, and we put up several videos. Had a decent response to a few of them. And we'll continue doing the live streams. We're going to try to do a lot from Vietnam, so we're going to try to do some original content here in Vietnam, but then also as we travel around Asia, do some original content outside of that typical, the food stuff's always nice, and the cultural stuff, but just some daily life and really seeing what it's like to live here in Vietnam. I'd like for us to go up to Tay Ninh province and do some live streams in some of the more rural areas. Maybe see rubber trees and how the rubber manufactured here in Vietnam, and just live the life like a true local, not a big city local. I think the locals in Saigon or Hanoi live a very different life than those in a 3rd, 4th, 5th tier city, obviously. And if you think about the difference of living in small city USA versus going to Chicago or LA, it's a bit of a culture shock for those individuals to either way, to go into the small town or to go to the big city. I think it's even a greater shock here because there's such a wider disparity between the 4th, 5th tier city and a tier 1 city. The disparity is much greater, and there's just no exposure to city life in the rural areas. You spend so much time working. It's from sun up to sundown, and usually through sundown. Sometimes working through the middle of the night just to have food on the table. Whereas in the city, the city's life's a lot more westernized and a more Western approach. So hopefully be able to get out and do a little bit of that live stream stuff. So I think that'll be fun to do. But always going to be putting out the videos, putting out either trials. I enjoy the trial stuff. I enjoy the drama behind it. But then, I put out a few videos on Asian news. The big news coming out of China this week was really the biggest thing out of Asia, and the Congress in Beijing was eye-opening to see what happened to former President and President He he used to be the leader of China just 10 years ago, and he handed the reins, or not Hu, HU. He handed the reins over to now President Xi 10 years ago, and typically 10 years is the limit on serving as president. And we just found out that President Xi was elected to a third term. So very, very different situation going on in China, and it's developing, and we'll know more in the coming days, really what that means. But he's really positioned his Politburo and all the underlings that really run the country have really put in folks that are more aligned with him, and so he's going to have really unfettered control, and we'll see how the people react if there's significant changes, and I think part of this is his legacy as well. The last 2 years have not been good on mainland, not been good in Hong Kong, and we've got the issues brewing in Taiwan. I think part of it's his legacy, and he wants to clean that legacy up, and he wants to continue on the path that he originally laid out 10 years ago. So we're still waiting for the live stream to come back up. Nothing as of yet. Nothing. Still nothing. All right. Well, we will hang out for a bit more and just wait and see what's going on. Not a lot for us to do right now, but wait. And so we are coming in from Ho Chi Minh City. It is 10 o'clock p.m. local time. So starting to get late, not as late as it is for the Australian crew or the Korean crew. They're a couple hours ahead, I believe, at least one, maybe two. So just a recap for anybody that's just joining, we expected Darrell Brooks's mother and Darrell Brooks himself to testify today. The judge asked if the mother or he had any other witnesses, especially his mother was going to testify, and he continued to beat around the bush and to not answer. So she moved on and said, okay, no more witnesses. And then she went to clarify the information about him testifying. And he refused to answer any of her questions around him providing his own testimony. And so she eventually closed that option as well. And he said that he had forfeited that right to self-testify or to testify on his behalf. And she dismissed the jury until tomorrow morning. So it's expected that jury instructions will continue today. The judge is hopeful they get done today. I would be surprised if they don't finish those today, unless they've just not started them. But still, given that I don't think Darrell Brooks will be getting into too many technicalities. Again, that's from a layman. I'm not a lawyer, so I can't speak specifically to it. But I don't think that Brooks will have a lot of
the record appearances are as they were before. The record should reflect that.
It looks like we're back
continues
live.
to appear from the other courtroom. I would like to make a record regarding the audio and visual from the other courtroom. I've asked that one of the bailiffs who was present during the last session, present in that courtroom come to this courtroom. I'm going to put him under oath and have him testify about the audio. I also have information from Zach Tremaine, our IT specialist. He too will take the witness stand.
So they're just covering all their
bases. I just want to make a full record of
so that he can't say after the fact
decibel reading.
He wasn't able to hear, wasn't able to speak.
Right, we have
because what's funny with this was he would talk and answer or ask a lot of questions, particular to the case, and then she would say, "Mr. Brooks, did you understand or did you hear me?" He would say, "Oh, I couldn't hear you." So he could hear the question, but he couldn't hear any of the other questions. So it's just comical.
Thank you. Please have a seat.
And so we have the bailiff here to
your first and
testify
last names for the
that
record.
the sound quality was
First name is
acceptable.
Nicholas, last name is Kibler, first name Nicholas, last name Kibler.
Thank you. And you are a Waukesha County Sheriff's Deputy?
I am.
And have you been assigned to work this case?
I have.
And were you present in courtroom 20 this morning with Mr. Brooks when he was removed from this courtroom to that courtroom?
I was.
And did you make any personal observations regarding the audio and visual setup that we have over there?
Both the audio and visual were working properly. The audio was a lot louder than it has been in the past while we were in that room.
Did you have any difficulty hearing the court?
I did not.
And then, of course, you could see through the cameras from this courtroom and the neighboring courtroom.
I could.
All right.
Oops,
That's
it's
the only
quite a
record I
mute.
wanted to make. State, have any questions?
Just briefly, Deputy Kibler, the defendant asked many times if he was muted or unmuted. Do you remember that?
Yes,
Can you confirm that even on the occasions when his microphone was muted, the audio in the courtroom continued to work?
it was.
And at any time while Mr. Brooks was muted, or even if you didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not. He is telling us he prefers right now to be in that courtroom. He did not want to.
I mean, of course, we all
Thank you.
know it.
Those are all my
It's just a
questions, Your Honor.
technicality of getting it on the record.
Mr. Brooks, you are unmuted. Do you have any questions for this deputy?
You
All
heard
right,
that.
thank you.
Yeah.
You may step down.
He knows he's caught.
All right, then I'm going to have Zach Tremaine also take the witness stand. Do you have- Can you do a project it, please? Yes. All right. There is, first of all, sir, stand and raise your right hand. Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? All right, thank you.
Because
Seated. State your first and
The
last
IT
name
guy
for the
wasn't
record, please.
expecting
Zachary Tremaine,
to be on the
Z-A-C-H-A-R-Y.
stand today.
Tremaine is T-R-E-M-A-I-N.
Oh, God.
All right, and what is your position with the
He's got
clerk
that
of
three
court's office
button
here in
up on
Waukesha?
good.
I'm the IT coordinator for the Waukesha County Circuit Courts.
Were you in courtroom 20 this morning following Mr. Brooks being taken to that courtroom?
Only temporarily. I was there when the call started, and then we came back to do a measurement of the DVD here later.
There's a document or a photograph that's displayed on the monitors throughout this courtroom. Can you tell me what we're looking at?
So my phone is in the photo, overlaid on top of what we call the X panel. It is our AV control
Going to
panel.
all
So you
these
push
measures
buttons on it
because
and
Brooks is
actions
on.
happen into the courtroom, AV
Jackass.
related. At that time of the photo, my phone is registering 67.3 decibels in that courtroom, and that was when the judge or the court was talking, and then the sound was coming over the speakers in the other courtroom.
And what, if anything, based on your training and experience, can you tell me 67 decibels means?
It's plenty loud. For comparison, I did a quick reading in the media pooling room, which is CG6 in our courthouse. The meter there was reading between 55 and 65. So it's louder than the audio feed going to the media right now.
All right, thank you. Any question from the state?
Sir, I'm looking at the photo, and Your Honor, for the record, this photo will be made a court exhibit?
Yes.
Okay. I'm looking at your phone screen, and it looks like in the upper right-hand corner, you it appears the time is either 9:26 or 9:36 a.m.
On my phone, yes, I believe our AV processor, which is the other time of 9:23, I believe that just needs to be updated, but
Okay,
it is approximately 9:26 when the photo was taken.
those are my questions.
All right, thank you,
Wait,
Mr.
I'm sorry.
Oh, go ahead.
Do you happen to know what the decibels are in this room?
I don't. I'd have to pull the same thing up on my phone while people are talking.
Thank you.
Mr. Brooks, any questions for this witness?
For the record, I don't consent to being called that name. Do you know anything about
Back to the name issue.
the hearing when someone has hearing loss in any of their ears?
I do not.
He's
So
mentioned this
it's fair to
before.
say
He's
you don't
mentioned that
know
he
if I can
can't hear in one of his ears.
his courtroom.
I can tell you what the readout of the room is. Beyond that, I don't know.
Well, I can't see what photo that everybody else is in there seeing that was supposed to be that exhibit. I have not viewed that, so I don't know what's being referred to when you refer to the picture.
I'll have to show you that in a different way. I don't have the Zoom up and running, which would have been the mechanism to allow for an exhibit to be
that's
displayed.
Gonna be
I
grounds.
can start that.
He's going to
and
say
have
that's
that
grounds
up
for a mistrial.
momentarily. Fair enough. So give me a moment. For the moment, we'll print it in black and white so you have it until I can get the Zoom up.
Painful.
Sure.
You are in the meeting now.
Jeez.
I need to get the other courtroom in, so just one moment. Will I have to stop the Polycom, Zach?
Yep, you have to hang up and then join into the Zoom meeting.
Okay, hold on, please. Can you do that? Stop the call Polycom to Polycom, and then I'm going to call it in through the Zoom so I can share the screen with the exhibit, which will actually help when we do jury instructions. Yep.
This is just painful.
Except now both room systems are out, so hold on. One more.
You are in the meeting now.
All right, so the record should reflect that I've now changed the audio visual from the Polycom unit to the use of Zoom. I've called in both courtrooms and they can hear from over there. And then I'll do, I just need to get back on so I can get the email. Give me a second. I have to go from double screen to single screen the way I sign in, but that'll take me just a second. And then I'll share screen so the color exhibit can be viewed by the defendant. All right, now the court is sharing screen and the image is being displayed. You see it? Okay, thank you. Any questions regarding that then, sir?
My question was, pretty much already answered. You don't know if me myself can hear everything good from your courtroom, correct?
I do not, correct.
No further questions.
Okay, thank you, sir. I'll stop sharing. Okay, thank you, Zach. You can step down. All right, I just wanted to put that on the record since that was an issue raised by Mr. Brooks previously. Now, I need to get a copy of the jury instructions. They were quite lengthy. The record should reflect that Mr. Brooks was provided with a written copy. It's 107 pages, and the state was provided with a written copy as well. Again, it's all the same 107 pages, and then
This will be
the
fun.
written copy is on its way.
Let's hold on.
I said the value, return the value document. That's if I'm not muted.
You're not muted.
I also would like to, again, ask for subject matter jurisdiction and proven on the record.
Your request is
It
denied.
has yet to be verified. It has yet to be verified.
Your request is noted.
Your Honor,
It's denied without further hearing or consideration.
I was just told that, the evidentiary phase is supposed to be closed. How come I haven't been able to present my evidence into the record as I've asked numerous times on the record to be able to do? I've said I have numerous documents that needed to go into the record. Why have they not been permitted to be made evidence? I didn't rest my case, so I don't know why that's being told. And I have yet to be able to offer my exhibits into the record for evidence. How is that so, Your Honor?
So the court did declare the evidentiary phase of this trial closed. I specifically found that you forfeited your right to present any further evidence or testimony when you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for that reason, I'm denying your request to make them part of the record.
Wow.
They were not hearsay, Your Honor. I did what you told me to do. You told me, since I was representing myself pro per, that I had to write everything out and present them to the court.
So that's not what I said. You're misquoting me, but in any event, I'm denying your request. I said.
So you're saying that I have no right to present evidence and to have exhibits as the state's been
painful.
Mr. Brooks, I'm not going to have a debate about this now. I got a mute him once again. So,
you know, when I watched
muted you,
Ricada and Legal Mindset and
I declared the evidentiary
Legal
phase
Vices,
of
and these guys sit through this trial specifically.
You forfeited your
how
right to
painful
present
it is.
further evidence and testimony.
Yes, it's extremely painful.
Previously, by refusing
I guess,
to
I mean,
answer
when you're
the
sitting
court's
and
questions.
watching,
I will specifically address the filings. Number one,
when you're watching
it
the
is
live
not
stream,
true that I
you know, you're doing
advised
so
him
many other
that
things.
any filing
So,
would become evidence.
you know,
That is simply
ears
false.
perk up when
Number
Brooks is,
two,
you know, going off on a rant.
Filings,
But when
I
you're
told
just
him
sitting here,
if he wanted to
for the most
present
part,
motions, should be written down and should be based in law and fact
yeah.
and request specific relief. I'm well aware that previously he has referenced
So
he would like his filings made exhibits.
it's
I
tough.
reviewed those filings.
It's much
There's
tougher to
nothing
host one of these
relevant, nothing
things
probative, or
than you
the
realize.
information contained therein is
I've
hearsay.
sat down and watched Ricada,
Mr. Brooks would have needed to testify regarding any statements that
when you just got to sit here and
from himself,
yeah,
testimony. He
pretty
cannot simply put in
mind-numbing.
an affidavit. That's not
But it's
proper.
okay.
That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth any exception to the hearsay rule that would allow this court to admit his written filings. I believe without fail, they are all irrelevant, not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback regarding jury instructions. It's typically a back and forth. We'll go through them. And I'll ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that. And then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Muted.
Right, you're unmuted now, but but you have to not interrupt.
You can't, I'm not trying to interrupt, but how can you deny me the chance to put on the adequate defense by saying nothing that you told me to do can be presented into evidence? So you filed them, you filed everything that I gave to you.
Right,
filed.
Mr. Brooks, I'm going to mute you because this is not relevant at this time.
It is.
He's raised tone of voice. He's very animated. He threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify, which includes the right to present evidence as you would have testified. I closed your, and I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I've referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction conference. It is his choice. But if he is going to spout off
I'll be right back.
about things that I've already determined, I will continue to exercise the mute function on the audio equipment. I'll unmute him again, but you are advised, sir, you need to be proper. You need to not interrupt, and you need to stay on task, which is we're discussing jury instructions, not other evidence, not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions. So once again, I'll unmute him to see if he can follow these simple rules.
You need to tell me why I can't present evidence. How can you deny me the fact? How can you deny me my right to present evidence?
All right, I'll mute him once again because he wants to continue. And again, I understand he's upset. I understand that. But he has himself to blame for his conduct this morning and the rulings that I've made. All right, so let's go through these jury instructions. First of all, has the state received a copy of the draft?
Yes, Your Honor.
Thank you. Mr. Brooks, do you acknowledge receipt? I believe you did by acknowledging it previously, but do you acknowledge receipt of the draft of the final jury instructions?
I don't acknowledge nothing, and I don't acknowledge anything now. I have not received anything.
I would ask the bailiff to pick up the documents from the floor and put them in front of him.
And I'm not presenting it to nothing I don't give my consent to. You can't deny me the right to put on a defense. How can you tell me when I done stated
I'm going to read it once again because, again, I understand he's upset. If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf. I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count 70. No, I don't want to do that. What do you got?
I guess I missed anything.
76. The 76 count. Just want to make. It says near Frame Park, so it is in there. But that was just
What's
one
he
question
doing
I
now?
had. All right. So, state have any requests as it relates to the jury instructions?
I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far.
Okay. Fair enough. There's 107 pages. I certainly can give the parties some time to continue to read through them.
he's built a little fort. He's not going to even take anything from the judge. Wow. I mean, it only reiterates the judge's case. If he's going to act like this, I mean, the whole thing, he acts like a 8 or 9 year old boy. Just ridiculous how he's acting. He acts like a little boy that doesn't get what he wants, and then he, moans about it and thinks he's going to get his way.
Mr. Brooks is requesting to go back to his cell. At this point, I'm going to deny that request. He can remain in the other courtroom.
I love that he peeks through it. Earlier, he's reading the Bible. He's reading the Bible, acting like he's here. And then he wanted to see where they're going. So you see him lift the Bible up and just look through the little hole he created. So funny. Maybe he's doing some rap. I don't know if you've not seen his rap video that he put out. Certainly worth to look that up.
I know he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs. I can't decipher what he's yelling.
So he's going off. That's great.
I'll advise Mr. Brooks, without a specific waiver of his right to be present, even if it's from the remote courtroom, he's going to remain in that courtroom. And that would require him to have a colloquy with me. Mr. Brooks, I know you are still muted by me, but I know the audio is working, but I would ask you to specifically advise if there are any specific jury instructions that you are asking be read to the jury.
What's he gonna do? He's so bad. He's got his handwritten notes. Oh gosh, and he's on mute. He's actually wants to say something, and he's on mute. Oh, it's sad though. I mean, the guy's absolutely nutso. Looks like he's screaming. Looks like he's yelling. He's
Mr. Brooks, if you have specific instructions,
one unhappy camper,
or categories of instructions that you believe this court should consider, I need you to write them down on a piece of paper. If you don't have, I believe I see a writing utensil. I'm not sure if I see a pad of paper. We'll make sure you have that. But given your current demeanor, which is still seems quite animated and a loud raised voice, I'd ask that you write it down.
I'd say so. Wow. giving him time to, I guess, write everybody needs to down and provide it to the judge. We're going to need something to fill these dead
How's the state
dead periods.
review? Okay.
Ooh. Just speechless. It's just dead right now. Nothing to say.
I just want to make a continuing record that Mr. Brooks is still, I can still hear him even though he's muted due to his level, his tone of voice and volume level that he is using from the neighboring courtroom. So all of these should be included. But they just put them in numerical order. So you hopefully haven't taken out any numbers. I can figure it out. There are numbers. Well. Yeah. So that's just the easiest because this goes after credibility. And then.
Ooh.
Which it's before defendant elects not to testify, and we have to toss up that one. Yeah. Mr. Brooks, I'll advise you once again, if there are any specific requests for either instructions or categories instructions that you want this court to consider, please write a note to pass to the bailiffs who can let me know.
I just love that he's built this little fort. Built this fort around him so that no one can see him pitching a fit that he didn't get his way. Now he just keeps getting upset. It is just great to see this from him. This is what I wanted to see on the stand today. I wanted to see him get this irate. I mean, obviously you don't want it for the families. You don't want to, he's playing these games, and the families are the ones that suffer. And there's entertainment value in just seeing how crazy he is. Well, I didn't know Uncivil Laws was streaming the case as well. Good numbers for him as well. 2.3 thousand. Yeah, 2,300. Good. That's awesome. Well, it seems that the judge is giving everyone time to read the full 107 pages. Oh, it is. I mean, it's been a slow morning. It's really slow now. I guess that's why she thought it might take through tomorrow to get through the jury instructions. Certainly hope not.
Your Honor, the state has reviewed all 107 pages.
Thank you. I know upon my review, I noted a few spots that either in the headings, that some information or words that might need to be removed. But why don't you go through and tell me what requests you have starting, and then we'll go page by page and just tell me what page number and what section.
So I think the first concern I have is with regard to the bail jumping. I know that we had charged, there's 2 separate felony cases. The defendant was out on bail. And I do believe it would be assistive to the jury to have the specific case number. So when we first talking about 61 of 107, we start talking about the bail jumping, and then we go specifically on page 63 of 107, and when we talk about count 74 and 75, I think it might be helpful to put the Milwaukee case number, because they are different case numbers, so that they know exactly what they're finding, that he was out on bail and that as conditions of his release. And those bail bonds were entered into evidence.
Let me look at the information.
And then just, because I think this was just well, I guess I'll have you, when we look at the verdict forms on page 102 to 107 for the bail jumpings, there's verdicts for the bail jumpings for 3 separate counts, 74, 75, 76. I don't think there should not be one for 76. I believe that should be the battery.
That would be true.
Got a hot mic. I mean, it's just, I don't know, it's going to be all day of this. Oh, but we will continue on. I picked a great day to do my first live stream.
Just acting up a bit, so I'm going to search and see if the information
pretty brutal.
says. And then I'll ask Mr. Brooks if he has a position on that.
Yeah.
Sometimes it's easier
The
if
pain
we
is
just list
real.
out, I guess, what the changes are requested. I'm going to make some notes and then we'll go through them one by one. But so,
And I don't
first is
believe it
page-
was spelled out in the amended information.
Say that again?
I don't believe it was spelled out in the amended information.
Right.
I wish they would just
So that would
hand the
be
camera to
page
Brooks and just keep it on
63
Brooks
of
as these
107,
folks are
whether or not we
talking,
want to put the
and
specific
seeing
case
him
numbers.
flail his arms and act like an 8-year-old
I can tell you right
didn't
now, I'm
get
typically like
whatever
to
it is
follow
he
the
wants.
information, so I'm probably not inclined to do that, and we can argue that though to the jury. But
Okay.
let's go through the list, and then we'll get
Okay.
the defendant's responses if he's would like to give us those. But we'll go through the whole list. So that's the bail jumping.
Yep, and then with the verdict forms with regard to the bail jumping, just to put on the record, page 102 of 107, I believe there's a count 76, which details it as a bail jumping. I believe that should be the battery. I did notice on
It's a little dead right now. The stream's
motive
not very
instruction
active,
was
but this is
incorporated,
my first ever
on page
live
5
stream,
of 107.
and it's not the most riveting of content that we are
And I
streaming.
know that intent is
Quite boring,
an
actually.
element
But
of the
so this
battery.
again,
I don't
this is the
believe that
case
was
of
incorporated.
Darrell Brooks,
usually it's a standalone
the gentleman
instruction.
who
I think the court incorporated
allegedly,
it with
quote
the
unquote,
first
allegedly,
degree intentional homicide, because certainly that
used
was
his van to run over
I think
the
that's part of the
folks
pattern
in
instruction.
Wisconsin.
Oh, it is. Okay, then we'd
during
ask
the
for
parade.
motive. I
And
think
that
that there's a 175
parade in
instruction
Wisconsin.
that could be given
Pretty
as a
cut and dry.
standalone.
You see, they've got images and video of him in the van driving,
I'll look at that.
and eyewitnesses galore saying he
And
was
then
the man
on page
driving, and it
65
was,
of 107,
it was his. I think it registered in his mother's name,
which
but
is the 70,
it's
the
quite evident.
preliminary
But
instruction, defendant
the crazy
proceeded
thing is he wanted to
pro se.
defend himself, and he was
There's the
he
standard
was
paragraph, which is the first
evaluated
paragraph
and
listed under this instruction.
evaluated
and
as
then
mentally
there's
sane.
an
So they
additional
allowed him to
paragraph.
evaluate himself, or
They are
to
going
represent
object to
himself.
that additional
But that just
paragraph. I think
really
it
caused
highlights
issues.
the defendant's
He
bad
didn't know the
behavior.
law. He
So I'd ask that
continued to
that
argue with the
taken
court
out.
over and over and over. And anytime he didn't get what he wanted, he would cause a big problem and pitch a big fit, and at times cry like a baby because he didn't get what he wanted. But he just didn't know the law. And the judge bent over backwards
All right, I made a note
numerous
of that. Keep
times
going.
Okay,
to
with regard to page
not show any
106 of
favorability toward the
107,
state, to give him ample opportunity to make his case,
I believe that those were
despite
add-ons at the
the
end that the
interruptions.
court wanted
So
to
about
question the
once a
parties
day,
about.
he
Yes.
would
I believe that
cause
there
a big
was
outburst, and he would
25
be
should be
put in
given.
the auxiliary courtroom where there's
One of the
microphones
witnesses for the
and
state did
cameras, but
testify.
he would be
did
muted
have one
because he
prior
just wouldn't
conviction. I believe a
have any
witness
civility
for the defendant
whatsoever.
testified that he had a
And
number of convictions.
that's what happened this morning. He again, because he's representing
With regard
himself,
to that same
he had
page
called
106
a
of
couple
107
of
and instruction
witnesses last week,
141,
and
where
today he was
identification of
expected to
defendant
call his
is an
mother
issue.
and possibly himself
I don't know if it
testify.
is an issue.
And
that wasn't raised during the defendant's
Judge
closing
gave
arguments.
him opportunity to call his mother,
I mean, sorry,
and
his opening
he
arguments.
did not
I
do
would
that.
know
And
that,
he kept going around the situation, and then
the defendant would
the judge
sometimes
read
cross-examine
him his
people
rights
on
about
if they were
testifying.
able to see the person
That he did
driving
not have to,
or
but
the
that it's
description of
up
the
to him if
person
he wanted
driving, and
to.
he would
He
cross-examine
refused to
them as
acknowledge
to
any of the
their
judge's requests
ability
after
to
multiple
perceive that. So I guess that would
attempts.
really be up to the
And
defendant
she
if he
finally
wishes that
moved
to be
on
given.
and closed the case.
On page 107
That
of
closed the
107,
defense's case
instruction
on his behalf
172,
because he simply
circumstantial
wasn't wanted.
evidence, flight, escape,
So
concealment.
right now
the
they are
state that
doing
was
jury
included
instructions,
in
which is
the
107
initial,
pages of jury instructions.
instruction that we
So they're going through
requested, and I
each
would continue
page
to request that
to make any
instruction
changes
included.
that may be warranted.
It's really just
Obviously,
flight,
this is
though.
pretty much one way
Correct.
because Brooks isn't
number again?
participating. So it's really the state and the judge
It's not that.
finalizing his jury instructions, and
I saw it.
they'll get Brooks's okay
Only
if,
has to
if
flight, I
he
mean,
wants to give the okay or he wants to
not
make
flight.
comments, but chances are he'll continue just to sit
And I'd
behind
say
his
concealment
boxes.
to
He's
some
made
extent, because he
he
took off
stacked
some
up
clothes
boxes
that
in
would
front
have
of
identified him.
where the camera
But
is showing
again,
him
his running
because he
away,
doesn't
his
want
trying to
anyone to
conceal
see
his
him.
identity by
And
removing
yeah,
some
so that'll be it.
clothing that would have
The
been,
judge
was identified
expects
by
jury
many
instructions to be finished
numerous
today or
witnesses
maybe tomorrow,
as
and then
him
it
wearing
will
a
be
hoodie or
closing
a
arguments
light-colored
and go to the jury, which
top.
don't think the jury will take long to deliberate this one. Really, it comes down the two types of verdicts. In Wisconsin, I
Those are
don't
all-
believe
and
there
do you
is a
have
death
any
penalty, so the death
requests as
penalty is off
relates
the
to
table.
Instructions that
For
are
this one,
not
then it's
in
either a life sentence or a life
the
sentence with
packet that should
possibility
be.
of parole.
No, Your Honor.
So
Let me
Brooks
turn to
really, his
Mr.
only
Brooks to
defense
see
was
it.
to
When
try to
he
get
has
that
any-
lower
his list,
lower
we're
charge
not asking
of
for a response
life
yet,
with
Mr.
possibility.
Brooks. What I'm
But
asking you for
given
is
given his
whether
arguments and given his
you have
rants,
any
I
requests
don't think he'll get that.
for
So I
jury
think it'll be
instructions,
life without the possibility of
or
parole.
in your review, you think anything needs to be changed, deleted, added, etc. I know I'd ask that it be put in writing, but I'll also give you this opportunity to verbally advise the court and make your requests. Do you have any requests as it relates to the jury instructions, sir? I would note he put two boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off, so I can see the outline of his arms. I can see the jacket on the back of his chair.
Come in close so nobody can see him, like a
Confirm
like a little
previously
boy
regarding
who's
the
upset.
audio working, and I will just ask him a second time, sir, do you have any requests as relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so
Yes,
we
I
can
think
see?
that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks.
Here we go. This is what we've been waiting
I
on.
don't know what he's doing behind there. He has quieted down. I haven't heard him in a while. If you could move the second one because it can interfere with the microphone as well. And the third. Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions?
It's the best part of the day. Now he's upset. He's gonna make some excuse that the judge isn't allowing him to have his documents
from the packet that has been provided to you.
Why do you tell them to move my box?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey, man, you don't got to talk to me like that.
Do you have any requests
First of all,
related to the jury instructions, sir?
Yeah, I got requests. It ain't like they gonna be honored though.
As it relates to the jury instructions, sir, what are your?
I heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Mr. Brooks,
welcome to the club.
I'm tired of my rights being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the
so
jury
sad.
instructions?
I mean, I hate laughing because it's so sad for the families.
How you gonna sit up there and make decisions based on what you think I said when I didn't get consent for you to do any such thing?
Sir, I understand you may be upset, and I really do, but I've made my determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't.
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks.
It's too much.
I know the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you're saying.
Then you should put the headphones on.
Don't you understand? What about that don't you understand? If you see headphones, you can see everything. You can see boxes, but then you see headphones.
Have you asked for headphones to be provided, sir?
I shouldn't have to ask for them. I didn't ask for my boxes to be moved.
I believe they took them away previously because you were so agitated. They were perhaps afraid you might break them.
Yeah, I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop. You sit up here and do everything you're doing and think God don't see what you're doing.
Oh, come on.
You ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to the jury instructions?
Yeah, I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is
Yeah,
it?
I got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image, sir. Now it's all this, sir, and all this. I'm gonna get where I'm going. Trying to put on this little, like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
I need to know what your position is regarding the jury instructions, and I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumping when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
It's not double jeopardy. Your objection is noted. It's overruled.
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with? You can't do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb twice. I'm already charged with the same count in Milwaukee.
That's really the least of his problems.
It's the same bail jumping charge. So how am I charged with that here?
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in.
Darrell Brooks, Esquire.
Right, you can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
I understand your position. I'm saying it's overruled.
You always want respect, but don't want to give it.
Well, at least it's a bit more entertaining over the last 10 minutes.
That I've already been charged with. That is double jeopardy. You can't charge me for the same exact bail jumping that I'm already charged with, that I was charged with before this even came about.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
Okay.
That's the distinction.
Again, there is no distinction. It's the same charge.
It's the same offense. It doesn't mean it's the same factual basis, sir.
He is not charged with bail jumping with the data violation of November 21 in Milwaukee County anywhere. Further, the double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
All right, so we've addressed that, sir. What other requests do you have as it relates to the jury instructions?
I want to know why I'm even charged twice with the same thing. You can't charge me in pursuant to a case in Milwaukee that I'm already charged with bail jumping for. I'm already charged with bail jumping for that already. So you can't essentially say, oh, well, because you were already on bail, we're going to charge you.
It's a different data violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond from the Milwaukee County case.
Yeah, but I'm referring to the first bail jumping count. The first. I'm not referring to both of them. I'm referring to one of them.
My understanding, sir, is there's different dates of violations as it relates to that. So I've noted your objection now repeatedly. I understand it. Your request to, I guess, dismiss the bail jumping counts are denied.
I didn't say nothing about counts. I said one.
Whether it's one count or both, it's denied.
Am I not being understood? You can't charge me with the same charge twice. You can't.
It's two separate cases, sir. There's two.
Is it that 971.23? That refers to the double.
All right, sir, I'm not going to have an argument. This isn't fruitful. I understand what you're saying. You're saying there shouldn't be 2 counts of bail jumping. You believe it's double jeopardy. I disagree with that. They're separate.
I'm already charged with it, though.
This is a circular argument, sir. It doesn't change the fact that, from my perspective, two bail jumping counts are going to proceed forward. There's been sufficient evidence presented to warrant the jury being instructed.
They can't.
What other requests do you have,
I'm
sir?
gonna talk over you. Don't talk over me. Just like you don't want me to talk over you. Just like you don't want me to talk over you. Just like you don't want
Mr. Brooks, what other requests do you have?
And I just asked you not to talk over me. You've been making your record the whole time you've been over there. You had me muted. I didn't see no request over there. I didn't write nothing to go over there. I let you do what you was doing. No matter how egregious and biased it is, I let you do what you was doing.
So here he's going on another one of his rants. So this is the second or third one of the day.
Mr. Brooks, I'm going to refocus your attention to the jury instructions. All of your objections are noted. I understand that. If you can't answer my question, I'm going to move on.
You can't. I haven't given you consent.
All right, I'm going to mute him once again. He refuses to answer simple questions regarding if he has any requests. He just made an argument regarding the bail jumping, so clearly he has an understanding about the law as it relates to that. It may be a misunderstanding about the law and double jeopardy, but he made an argument. I've denied it. I'd like to know if he has any other requests. If he can stay on topic, I'll mute. I will unmute him again, and he can tell me the list, just like the state went through a list. I need to get through their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here is your opportunity to give me your other requests, not debate with me about prior rulings. Go ahead, Mr. Brooks.
Don't sit up here and try to play no games talking about you giving somebody an opportunity that you haven't gave me an opportunity to properly defend myself and put evidence, put stuff into evidence, which I've asked you repeatedly to do before we
really, it's just unbelievable.
You told me you wasn't in evidence very phase.
Mr. Brooks, do you have any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
At least.
No, it's not. So please stop being incorrect, Ron. Please stop.
Do you have any additional requests as it relates to the jury instructions?
Last time. Just move on.
Oh. That first count 74 bail jumping needs to be dismissed.
Back to bail jumping.
2 days. You can't charge me with the same charge twice.
All right, I've made a note of that. What's the next issue?
Either one county gonna charge you with it or y'all, but it can't be both. It's the same. It's pursuant to the same exact thing that I was gonna bill for. The same exact thing, same exact case. So why are we giving the jury instructions on 2 cases from another county?
I made a note of that. What other requests do you have?
Man, this is ridiculous. So I'm not even able to adequately defend myself, present evidence, do anything, because everything I say is gonna be found a reason for it not to be valid. What are we doing here, Your Honor? What is the
Mr. Brooks?
Why should I be here when
I've made a note of your request as to count 74. Do you have any other requests as it relates to the jury instructions?
That's all I can take.
Why are we even having jury instructions? Why do I have to even sit here in this courtroom at this point? Because everything you've been doing without my consent anyway. So you're gonna find a way to do this without my consent. So why do I need to be here for?
Your objection for lack of consent is noted for the record.
All right.
Any other requests, sir?
You talking good game to save yourself enough space. But everything got put up and has no merit in your court. Done.
All right, I've asked him many times. I've advised him, and I'll advise him once again. If he fails to answer the question, I'm moving on. Do you have any other requests as it relates to the jury instructions, sir? All right, he did not answer. So I'm muting him again. The only request that he has made as it relates to the jury instructions, as he pounded his fist once again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability to present a defense, but that decision was made based on his conduct and his conduct
Yeah, he had a
alone,
chance
as I
to
outlined
respond,
already
and
on
he chose
the
to
record.
do what he did.
So the only request that he made was as it relates to the bail jumping counts. I'm denying those requests, whether it be to dismiss one count or to dismiss both on double jeopardy, or to just not instruct the jury. However way I interpret it, I'm denying that. All right, let me go through the state's.
Rather, can I add one more?
Sure.
I'm sorry, 154 summary of evidence. I believe we had a map, actually 2 maps that summarize the, we had 3 maps. I think the one was summarized his route, the path that he took. The other one summarized the victims who were struck in the specific locations. And the other one summarized the positions of the law enforcement officers at the various intersections and throughout the parade routes.
I'll make a note of that. I don't believe I saw the jury view instruction either. I mean, that was given to them at the time. I don't know that it needs to be reread, but I think we need to consider that as well. And that was my version of one.
Here we go.
All right, so let me go through
Darrell the Builder
list from the state.
Oh gosh, I can't believe he's doing this.
Turning to page 61. So I've considered the request by the state. I am going to rely on what information they put in the charging document. I'm going to deny the request to include the specific case numbers. There's evidence, of course, that was received regarding the 2 separate cases out of Multnomah County that form the basis for both of the bail jumping counts. It will be up to the jury to review the evidence and make a determination. As to the verdict forms, though, that were referenced previously, at least the description of them in the jury instructions, that obviously the 3rd count of bail jumping is incorrect. That needs to be battery, and that change will be made. I'm also having Madam Clerk include all of the numbers for the jury instructions when they go back, so it's very clear. Some of them did not have them on, just frankly from prior cases that she and I have worked on, but in this case, I want to be very clear with all of the numbers. So I think I've addressed the first 2 bullet points. As far as the motive instruction as a standalone, I believe that is appropriate. I'll instruct Madam Clerk to include that. As far as where it goes, I'm going to just, any instructions that we add should just be in the numerical order, unless there's a other request that's made. Then the state also made a request as it relates to jury instruction 70, which is found on page 65. So as it relates to this, the state is asking that I simply
take a nap.
Instruct the jury based on the pattern instruction and not include that second paragraph. I had previously advised the jury with another paragraph that I was contemplating including, even if I took out that big paragraph that just said, at times Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any manner. What's the state's position on including that, but taking out the paragraph you request to be taken out?
It's fine.
Mr. Brooks, do you have any position on that? Which is, so jury instruction 70 has to do with the defendant proceeding pro se. The pattern instruction would be basically the first paragraph. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Otherwise, they need to be moved away from the microphones and away from from blocking his face.
I'm not putting in there. I'm not putting in there. I'm putting in there for a reason.
Mr. Brooks, do you have any position on the verbiage of jury instructions 70 on page 65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree with the state. I don't need to highlight with that second paragraph. I will take that out, but I will include in the paragraph that reads, at times, comma, Mr. Brooks has appeared from another courtroom, period. This must not influence your verdict in any manner.
Unbelievable.
Inclusion of the instructions that were put on the last couple of pages include 325 impeachment of witness. Its prior conviction, the part about juvenile adjudication, should be struck from the heading. And it should read, evidence has been received that one or more witness in this trial has been convicted of a crime. There were 2 witnesses that was applicable to. The remainder will be as is. And that was 1 witness for the state, 1 witness for the defense. I just will add that if Mr. Brooks has any position about these requests, he should,
really
he is
dragging
currently
on.
muted. He can raise his hand and I'll unmute. Otherwise, he can pass a note to the bailiff or simply tell the bailiff, who can then tell me and I can unmute him. But unless he tells me, then I'm going to assume he's made a decision not to provide further comment based upon the last statement he made to me. Then 141, I believe that's appropriate given the evidence that has been received. That's on identification of defendant is an issue. That I will instruct the jury accordingly unless there's a request from Mr. Brooks to take that out. Is there a request from you, sir, to take 141 out? I'll unmute for that purpose. It's found on page 106 because it's at the end of the instructions. This is the instruction on identification of the defendant and where it's at issue in a case. I believe it's appropriate given the testimony in this case. Do you have any position on that, sir? You are unmuted, so you can simply answer yes or no. No response. Then 172, circumstantial evidence, flight, concealment, I believe is appropriate given the evidence that has been received during this case. Yes, sir? You have been.
Am I unmuted?
You are.
So how long before you mute? As soon as I say something?
Depends on what you say, how you say it, and if it's responsive to what we're doing.
Why do I have to be responsive to what you guys are doing? Nothing I say even matters at this point. So what's the point of me being responsive? You can't make decisions for me.
Mr. Brooks, I'm going to mute you unless you can participate in what we're doing, which is discussing the jury instructions.
I'm gonna tell the jury the truth. That's what I'm gonna do. I'm gonna tell them what hasn't been told to me.
Your chance of doing that's a bit.
I haven't been able
Mr.
to.
Brooks,
I'm
I'm going to mute you because we're trying to discuss the jury instructions, not what you're going to say during your closing argument. I will get to that later. In terms of instruction 172, I'll instruct Madam Clerk to take out of the heading the word escape. Should just say flight concealment. And then I've reviewed 154. I believe that's appropriate. I'm going to pull it up just as a draft. I'm not sure if there's anything that needs to be. I'll
be right back.
So So the pattern instruction talks about a chart. Is there any request from the state as to just keep that or modify that in any way based upon the evidence that was presented? Because you actually submitted maps and things were received. I don't know that summary.
I think that there was a summary of the victims and the associated counts. I believe that was exhibit 141.
But that was received, wasn't it?
And there were some charts of the extreme dance team, the formation, and dancing grannies.
Do you have the exhibit list, Madam Clerk? What are those numbers again? I wrote 141.
We're just looking for the extreme dance and dancing granny charts.
Cool. What did I miss? Everything?
4 would be the dancing grannies.
Okay.
And 33 is the extreme dance team.
So 54, 141, and 33?
Yes.
Do you think the use of the word chart is correct, or should that be?
I would say diagram and maps. The court has allowed the use of diagrams and maps to organize the evidence.
The maps were evidence, though. What this instruction says is the court has allowed the use of a chart to organize the evidence and to assist you in understanding it. The chart itself is not evidence. It is a summary of some of the evidence that was permitted or presented. However, it is the evidence that controls. You should rely on the chart only to the extent that you believe it accurately and properly summarizes the evidence.
Then we think 154 should not be given.
That's what I was wondering.
Because they were all admitted.
They were all admitted based upon how they were presented and the testimony regarding them. Typically, where that comes in is for use in openings and closings solely that are based upon evidence, and we anticipate those things coming in, not when there's been an actual document that's been admitted. So I don't think 154 is needed, and I'll deny that request. What about 152 regarding the view?
As I read that was given prior to the view, and I think that was appropriately given at that time. I don't believe it goes into the closing or the final instructions.
That was my inclination, but I wanted to get the party's position on that. I'll once again unmute Mr. Brooks and just ask him if he has any position regarding any of these last issues that we've discussed with as it relates to the jury instructions. Anything from you, sir, on the jury instructions?
Okay.
He's not responding to the question. I believe that covers all of the issues that were raised by the parties then. You are. I'll give you one final opportunity to tell me if you have any requests as it relates to the jury instructions, sir. I understand, sir. Your objection's noted. Your lack of consent is noted.
Okay, I don't see what's going on in here.
Yeah, come on.
Decisions being made without we being able to consent to it.
Sir, you forfeited your right to be present in this courtroom by your
Too
conduct,
much.
and you have not requested to come back.
Actually, you took a break. So let's make sure the record is correct. You took a 10-minute break.
I did.
At which time I was brought back into this courtroom.
I was advised you wanted to stay, sir.
Okay, and you've been forcing me to come over here from the get-go. Why couldn't you force me to come back over here where I'm supposed to be at?
Sir, my understanding is you requested to stay in the other courtroom. I thought I put that on the record at the beginning. If I did not, I'll make that part of the record now. I was advised by the bailiffs that you were requesting to stay in that courtroom. I certainly advised you prior to that if there was a time you wanted to come back in, all you needed to do was ask. You've done that previously. And even during this time, though, you've been incredibly disruptive. At one point you were muted for an extended period of time and you were yelling so loud, sir. We could hear you in this courtroom. I couldn't decipher what you were saying. And I was also made aware that another branch could hear you. So you continued your disruptive behavior.
That's fine, because at the end of the day, I should be heard. I have this First Amendment right to be heard. So if I'm going to be constantly muted, the only way for me to be heard is for me to raise my voice.
Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them. I'm going to take a break and
don't entertain it.
We'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no, so how do you consent to anything without me answering the question?
Are you going to answer the question, sir?
You can't force me to do it. You can't just say, I'm going to do this.
Sir, but you also can't stall the proceedings by failing to answer.
I didn't try to stall the proceedings. You're the one that held me in contempt.
I never held you in contempt. All right, I'm going to mute him once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions. I will work on making all the changes with Madam Clerk, finalizing the order, print them off again. She has been working on the verdict forms, which are of course separate, which need to be approved by this court. So those will be printed off. A set will be provided to the state. A set will be provided to Mr. Brooks. We'll take I'll do a 90-minute lunch break. So it's 11:27. So we'll come back at 1 o'clock to finalize the verdicts and the jury instructions.
And Your Honor, with regard to sequestration of the jurors and the alternates and those issues, did you want to address those this afternoon?
Yes.
Okay.
We can do that.
Thank you.
I can put on the record that I had the civilian jury bailiffs provide the parties. We have a letter regarding sequestration. There's an emergency contact form. So all of the jurors were made aware of that. They know that. Of course, once the case is all of the instructions are read and the parties make their arguments, and then there's some final instructions.
Good thing it's getting to lunch.
And the case goes to the jury. Obviously, only 12 of the 15 will be deliberating, but we can make a more full record of that this afternoon.
Thank you.
All right, we are in recess until 1 o'clock. I'm just instructing the parties to stay until the handout of the verdict, and then you can leave for lunch. Thank you.
All right, folks. Well, I think with that, the few that did jump in, thanks for coming into the inaugural stream. There wasn't a lot of activity either on the live stream or within the chat and with the community, but we're building it. So we start small and we build it from there. So thanks everyone. I think I want to leave it here. Maybe do another live stream of some different content later. I don't think I'm going to watch the rest of this day. It's just too dry. And not enough going on activity-wise to comment on. So thank you. If you've not given me a subscription, I would very much appreciate if you subscribe to the channel. That helps me grow, helps keep the momentum going, keep everything going in the right direction. So please give me a subscription if you can, but please do like the video as well. Anyway, thank you so much for watching and have a good day. All right, bye-bye.